Is it possible to get a J1 waiver based off hardship only to a child? That's what we're going to be talking about in this video, so you'll want to stay tuned to learn how we did it. We're going to be discussing in detail the arguments we made in our legal brief to get the case approved. My name is Kaushik Ranchod from the Ranchod Law Group, and we represent J1 waiver clients across the United States. So stay tuned because you're going to learn some insights that perhaps you may not even know about. Is it possible to get a J1 waiver just based off of hardship to a U.S. citizen? That's a great question, and we're going to be talking about it in today's video. My name is Kaushik Ranchod, and I'm an immigration attorney. We represent clients throughout the 50 states, so stay tuned because we got some really interesting information for you. J1 waivers. Some people call it the J1 disease, needing this J1 waiver, which is the cure. So if you have this 2-year rule, I think it's a little bit morbid to call it a disease, so let's put a positive spin on it and call it the 2-year challenge. Legally, this is the 2-year rule where you have to go back for 2 years to your home country if you're subjected to the 2-year rule. But let's be positive, let's think positive, let's talk about how can we overcome this 2-year rule. And I'm going to give you a variety of tools that you should be aware of to overcome the 2-year rule. We're going to focus on the exceptional hardship waiver, but I want you to be aware of the no objection waiver, where you could get a no objection statement for your home country. There's also the J1 persecution waiver. If you've been persecuted, there's a chance of persecution in your home country. There's interested government agency waivers, such as the Conrad 30 waiver for physicians, the VA waiver. But we're going to talk about the J1 waiver. The J1 exceptional waiver, first of all, you have to have a qualifying relative. That could be a U.S. citizen or lawful permanent resident child, or a U.S. citizen or lawful permanent resident spouse. In the case that we're going to be discussing today, there was only a U.S. citizen child that was the qualifying relative. Here, our client was from a Middle Eastern country, came into the United States, and he was on a J1 visa. His wife was on a J2 visa. While they were here, they had their U.S. citizen child. We made the argument that the U.S. citizen child couldn't go back to their home country. One of the reasons was because their child was well adjusted, they were in preschool, so they're already getting adjusted as an American citizen to the American way of life. The child did not want to return to their home country. They liked the United States, and as a U.S. citizen, they should have the right to stay here. One of the big factors in the case was the country conditions. The country conditions in this Middle Eastern country had a variety of issues for the U.S. citizen child if they had to go back to the country. This included a poor educational system. So here, the child was available to have the top U.S. educational system, and there they would have to go back, if they went back to their home country, would have a very poor educational system. And that was not fair. That was exceptional hardship for that child. Additionally, there were safety issues that could occur if that child had to return to the home country. Another big issue that was there was the unavailability of medical care. The medical care in our client's home country was not comparable, and therefore the U.S. citizen child would not have comparable medical coverage in the home country. Another factor, and this is very common for many of our clients because many of our clients are very intelligent, very smart, they earn a good salary here. If they were going to go back to the home country, they would not be getting a good salary. Because of that, even though the parents are not the qualifying relative, we make the argument that that hardship funnels down to the child. Because of that, the child would be affected by the fact that the parents would not be earning a good income in the home country. When preparing the case, we submitted the DS-3035 application with the Department of State. We prepared the legal brief and application to USCIS. And in doing that, this is very extensive on our part. What we do is we prepare. In preparing the legal brief, we do a lot of research on the country conditions. We audit all of the documents to ensure that we're submitting the most appropriate documents. You don't want to submit all documents because that could be overwhelming for the officer. You want to submit the most appropriate documents. So we spend a lot of time auditing the documents, suggesting maybe perhaps more appropriate documentation if you have it. So that's all a process. And of course, writing the legal brief. So then we submit the application along with our client's statements, and then USCIS, after making their favorable recommendation for approval, sends it to Department of State. Department of State then made a favorable recommendation, and USCIS issued a final approval. Currently, processing times are taking anywhere from 1 year and 7 months to 2 years. These times do change. It's dependent upon the government processing times. We noticed that within the last year, they stayed about the same. What I've seen as trends is that processing times are increasing. I want to thank you for taking the time to watch this J1 waiver series video. By bettering yourself, you're bettering your family. By bettering your family, you're bettering the world. Make sure you subscribe to continue to get informed. Share this video with your friends who may be in the same situation, because you never know if they need help as well to learn about their options. Bye for now.